This Honorable Court of Tennessee is now in session.
Welcome to the October session of the Court of Criminal Appeals, Eastern Division. On the panel today, Judge Camille McMullen from Memphis, Judge Jill Barty Ayers from Clarksville. I'm Kelly Thomas from Maryville. First, I want to thank Nick Morgan and Francesca Kraft for literally making all of this possible. They take care of getting everything going and getting lawyers and judges in the courtroom, etc. So thank you all. The times are the usual times, 20 minutes aside. If you wish to reserve any rebuttal time, please let me know when you start and we will do that. I don't think there are any other preliminaries. If you will call the next case, please.
Yes, sir. It's going to be State of Tennessee versus John William Gay.
All right, Mr. Wilson.
May it please the court. Good afternoon, your honors. My name is Brian Wilson, and I'm with the Appellate Division of the Public Defenders Conference here on behalf of John William Gay. May I please reserve 3 minutes of time for rebuttal?
You may.
Thank you, your honors. We are here today regarding convictions out of Bradley County of aggravated robbery and theft. We argue that the proof at trial failed to establish Mr. Gay's intent as necessary to convict him of either charge. In addition, we argue that the trial court erred in issuing a maximum sentence that may keep Mr. Gay in prison for the rest of his life. In either case, we ask this court to reverse these judgments and either vacate the convictions or order a new sentencing hearing or a new sentence. Your honors, this is a case that's largely tied to illness. It's a case where a man attempted to hurt himself and then was then accused of hurting others. Mr. Gay has a long-standing history of physical issues and mental and emotional issues. And on the night of the offense in 2017, he mixed alcohol with pills in an effort to overdose and take his life. He blacked out the night of the incident. And when he came to the following morning, his son called him and asked him, what did you do, Daddy? He had been accused of robbing a store at knife point overnight. Mr. Gay was tried and convicted in 2019 of aggravated robbery and theft, and then was sentenced to a 12-year term, the maximum under range 1. He is eligible for release no earlier than when he's 80 years old. Your honors, we argue today that the evidence produced at trial was insufficient to convict Mr. Gay based on his inability to form intent at the time of the incident. Largely, we are arguing that is because of the intoxication that Mr. Gay had put himself, the substances he had taken on the night of the incident. This is not merely proof of from defendant testimony. We also have police images that were taken from his residence the night or the morning following this incident, where there were images of empty beer bottles, empty beer cans. There's police testimony that confirmed that there were empty pill bottles that were around this apartment. Mr. Gay provided context to this situation and context to his intent when he testified in his own defense, saying that he had ingested these substances in an attempt to black out and to end it. He wanted to take his life. He had talked about traumas he had dealt with in his past and his mental health at the time. This evidence goes beyond what this court has used to deny a jury instruction on voluntary intoxication before. Mr. Gay was more than just probably drunk or probably intoxicated. There was proof that he had taken these substances and that they had affected his ability to form intent. This court has held that that intoxication can serve as a defense against, or at least negate a finding of specific intent. And at this point, we simply argue that Mr. Gay did not know what he was doing at the time of this offense, that he was unable to form an intent, that he was trying to harm he was trying to harm himself and not harm others. And while there is video of this offense that was placed into evidence, we argue that that the behavior of the assailant in this offense may not match what would be typical for Mr. Gay in a regular setting. Mr. Gay was in a wheelchair at trial. He has mobility issues, yet the person that committed this robbery walked pretty with little trouble. The clerk at the convenience store that night, Mr. Patel, testified that Mr. Gay had come into the convenience store before and had spoken with, or had not spoken consistently with the clerk. He merely bought beer and cigarettes and left. On the night of the offense, the assailant came in and struck up a conversation with Mr. Gay. I say all this to say that something was off that night, and that Mr. Gay was not his normal self. This is and because of that, he was not in a place where he knew what he was doing, whether by the substances he had taken or just the way he was behaving. I mean, where he was in his state of mind, given that he wanted to commit suicide that night. We argue that because of this, the evidence was insufficient to establish Mr. Gay's intent to commit either aggravated robbery or theft, and that this court should reverse these convictions based on that insufficient evidence. In addition, we also argue that the sentence given by the trial court was inappropriate in this matter. And we argue that, in essence, Mr. Gay received a maximum 12-year sentence, as much as he could receive as a range one offender for this offense. And this happened despite the trial court misapplying several enhancement factors. First off, the trial court said that there was more than one victim in this offense, naming the clerk and the store in this case. The indictment at issue only accused or only stated that Mr. Patel was a victim in this case. And this court has held that a trial court cannot name victims outside of the indictment when trying to apply this factor. And the trial court erred in doing so here. In addition, the trial court incorrectly found that there was no lack of hesitation when the risk of human life was high. The trial court only spoke about Mr. Patel, the clerk, as being the only person at risk during the time of this offense. And this court and the state Supreme Court has held over a long period of time that a trial court, when issuing sentences, cannot only speak of the victim in a case when saying that there was no lack of hesitation when the risk to human life was high. Now, there was also a third party that walked in, according to the video, during this offense, but when that happened, the assailant walked out quickly. There were no threats, there were no showing of a weapon or any sort. There was no risk of harm here. So even though the trial court didn't consider that here, we would also say that this wouldn't apply in a broader setting. In addition, we argue that the trial court failed to provide a larger context or just properly consider Mr. Gay's criminal history. We may not have, or I may not have explained this as effectively as I hoped in the principal brief, but what we're arguing here is that the language used for enhancement under this factor, whether there's a previous history of criminal conduct or criminal behavior, isn't the way it's applied and for purposes of enhancement is not aligned with how it is applied for matters of consecutive sentencing or whether incarceration is appropriate as opposed to an alternative sentence. There is similar language when in these three circumstances when dealing with criminal history, whether there's a previous history of criminal conduct or criminal behavior or a long history of criminal conduct or an extensive criminal record or an extensive record of criminal activity. There's similar language here, but wildly different interpretations depending on what part of the sentencing process is being performed. Under the current standard, a previous history of conduct as little as underage drinking or marijuana use that's testified to on the stand can be sufficient to enhance a sentence to its maximum. We argue that that doesn't really align with how sentencing is conducted in other ways in the state, and that a different standard that aligns more with consecutive sentencing or whether incarceration is appropriate would be more applicable here. In the present case, the trial court spoke of the 4 felonies that Mr. Gay had committed in one single incident in 2006. We argue that the trial court should have looked at that history as one single incident as opposed to looking at each of the felonies and using it to properly or to improperly build a case for why a maximum sentence is appropriate. In addition, we also argue that the trial court misapplied mitigating factors in this case in an effort to continue to build this reasoning for a maximum sentence. The trial court applied what it described, or the trial court said that there were other reasons for allowing mitigation while denying mitigating factors for age, physical or mental illness, or unusual conditions. The trial court, while granting this, what is colloquially the catch-all factor, talked about Mr. Gay's physical and mental illness. And it seems here that the trial court went against the language of the factor, which applies when there are other reasons or other circumstances that are present beyond the ones listed. Here, the trial court said, here are these factors that don't apply, but I'm going to use similar reasoning to apply a catch-all factor in limiting the amount of ways that a sentence could be mitigated. Again, we argue that the trial court here just continued to act in ways, whether by misapplying enhancement factors or looking at a criminal history offense by offense, by misapplying mitigation factors, and in a way that justified sentencing at the top of the range in this sentence. In addition, the trial court analyzed whether incarceration was appropriate as if there was some alternative sentence that was going to be applied here. That's not the case, considering this was an aggravated robbery conviction. This is a mandatory service of at least 85%. But nevertheless, the trial court felt the need to continue to build this case, whether it needed to or not, about why a maximum sentence was appropriate. The trial court said point blank that it felt like that Mr. Gay was sentenced in the wrong range, that a range 2 sentence would have been applicable here, and nevertheless, with saying that, with all of the separate errors that occurred in this sentencing, the trial court met this critical mass of errors that goes beyond the purposes and principles of sentencing. It goes beyond the least severe measure necessary in this case. We argue that the trial court abused its discretion by doing so, and that its sentence should not stand. We ask this court to reverse the sentence in this case and either remand for a new hearing, or if it feels that the record is sufficient in this case, to conduct an overview of its own. Your Honors, broadly, again, this is a case where one man tried to hurt himself, not to hurt others. The evidence presented at trial showed someone who could not form the necessary intent to commit robbery or theft at the time of the offense, whether by intoxication or by mental state. The proof was not sufficient to convict him of either of these charges, and they should not stand. In addition, Mr. Gay's maximum sentence was inappropriate and not aligned with the purposes and principles of sentencing. We ask this court to reverse these judgments and either vacate these convictions, remand the case for a new sentencing hearing, or issue a new sentence of its own. If there are no questions, I'll reserve the remainder of my time for rebuttal.
Thank you. General Ward.
Yes, good afternoon, Your Honors. May it please the court, my name is Garrett Ward I'm here this afternoon on behalf of the state of Tennessee in the matter of State versus John William Gay. Your Honors, here on direct appeal, the defendant challenges the sufficiency of the evidence used to convict him and suggests that the trial court abused its discretion in imposing an in-range sentence. Dealing first with his sufficiency challenge, I think it's important to note from the beginning, Your Honors, that the defendant appears to concede all elements of both aggravated robbery and theft other than mens rea. His challenge appears to be cabined to the suggestion that he was either so intoxicated as to prevent himself from being able to form the requisite mental state, or that his mental condition prevented him from doing so. Your Honors, the problem with this argument is that it essentially relies on testimony and argument that the defendant put forth himself at trial that was discredited, that was not given weight by the jury. Instead, the jury accredited contrary testimony. The jury accredited the testimony of Mr. Patel, the clerk that the defendant robbed. Mr. Patel testified that the defendant came into his store, waited for other patrons to exit the store, then removed a large kitchen knife, directed Mr. Patel to empty the cash register. Mr. Patel testified that when the defendant did this, he was not slurring his words, that he was clearly communicating. Mr. Patel then complied with the defendant's direction given at knife point. This was the testimony, this was the evidence that the jury accredited. And this makes good sense as the surveillance camera footage from the convenience store corroborates and substantiates much of what Mr. Patel says. This is essentially a case in terms of whether or not the defendant would be able to and did act with the requisite mental state. It's essentially a case of competing evidence. The state's evidence that the defendant acted with the requisite mental state was the testimony of Mr. Patel, was the surveillance camera footage. The defendant was certainly entitled to present his own evidence to the jury, and indeed he did.
Was intoxication as a defense, was that instruction requested?
Your Honor, the jury was instructed on intoxication. So the jury certainly considered, and as evidenced by their verdict, flatly rejected the defendant's evidence and argument that he was too intoxicated to form the requisite mental state for theft or aggravated robbery. They similarly rejected his suggestion that his depressed mental condition would have prevented him from forming these same mental states. This is the purpose of juries, to when there's competing evidence on both sides, to accredit one side above the other. In this case, the jury accredited the evidence of the state. The state's evidence, when viewed in the light most favorable to the state, was certainly and clearly sufficient to establish that the defendant behaved with the requisite mental state to be convicted of both theft and aggravated robbery. Turning to the defendant's sentencing challenge, Your Honors, this challenge may be rather easily disposed with. The trial court here enhanced the defendant's sentence by applying the criminal history enhancement factor. The application of this factor was more than supported by the record. The defendant's pre-sentence report reflected 6 prior criminal convictions. As opposing counsel noted, the defendant was sentenced as a range 1 offender. So all 6 of these prior criminal convictions were convictions beyond that necessary to establish range. The trial court was well entitled to rely on these multiple convictions to apply the criminal history enhancement factor and enhance defendant's sentence based on this factor. Your Honors, while the defendant does challenge and suggest that, well, perhaps the trial court considered too many convictions, that several of his convictions occurred in close temporal proximity to one another. The state would point to the arguments laid out in its brief, suggesting that this sort of single incident thought process does not apply here in the criminal history enhancement factor field, like it might apply in consecutive sentencing or even range establishment. That's largely beside the point. Even if defendant's argument is correct, even if he's correct to say, well, the trial court should have considered 4 of my convictions as only 1, that still leaves us with 3 convictions. Again, he was sentenced as range 1. So even if his argument is correct, we're still in a situation where the defendant has multiple criminal convictions, none of which are needed to establish his range, justifying the application of the criminal history enhancement factor. There is a number of cases from Tennessee courts holding that proper application of one enhancement factor is sufficient to impose an in-range sentence. And that's precisely what the trial court did here. The trial court properly applied the criminal history enhancement factor and then properly ordered the defendant to serve an in-range sentence. I'd suggest to this court that the proper application of the criminal history enhancement factor is strong evidence the court did not wholly depart from the purposes and principles of the Sentencing Act and imposing sentence, and therefore, under the standards set forth in Byes, the trial court sentencing determination should be left undisturbed here on appeal. Unless this court has further questions, I would ask that the judgment of the trial court be affirmed.
I'm sorry, Your Honor,
I said something, but nobody could hear me. You've got 3 minutes for your rebuttal.
thank you, Your Honor, I appreciate it. First, while the state talks about the nature of the jury in this case, we are here today on a sufficiency issue as a matter of law and whether the evidence presented at trial was sufficient for any reasonable juror to convict. In this case, we argue that that is not the case here, given the testimony regarding Mr. Gay's mental state and intoxication at the time of the offense. There were also a couple of incidents where the state described testimony. I believe he described Mr. Gay's testimony as self-serving in the state's brief. Yet at the same time, there is not a level of conflicting testimony as there may appear. Based on my recollection of the record, Mr. Gay or Mr. Patel had no memory of whether the assailant had any slurred speech in this offense. At the end of the day, what we're arguing here is that the proof here, again, did not establish whether there's sufficient intent to maintain a conviction on either charge. And because of that, we believe that the evidence was insufficient to convict and that this court should reverse. We also believe that this sentence or this sentence should not stand. I will note that the trial court merely talked about the 4 convictions tied to a single incident in 2016 for Mr. Gay and did not reference the DUIs referenced by the state. Relying merely on the cases that the trial court did here, we argue that one incident that each of these incidents should be considered as one, and that Mr. Gay's criminal history should be evaluated in that manner. If there are no other questions from this court, I'll again ask that you reverse in this matter. Thank you.
Thank you very much. Thank you for your arguments. you may put us in recess.
This Honorable Court of Tennessee is now in recess.
Thank you.